So, in victimology, we will cover some of the theories of victimization, and we will also look into the personal impacts of victimization. We will look into how it can be assessed, as well as describe some of the emergence and development of victims' right in Canada and identify ways in which such rights are recognized. We will also speak about some of the services that are available to the victims of crime and in what ways they are provided, as well as describe the concepts of victim restitution and compensation and how these processes work within the criminal justice system in Canada. As well as we will also look into some of the emerging directions in the field of victimology. So, the criminal justice system reference service in the United States developed a special website called Children Exposed to Violence. So, this site's creation followed a release of special report by the U.S. Attorney General's National Task Force on Children Exposed to Violence, and it was titled Defending Childhood. In keeping with the report's findings, what the website noted was that research suggests that witnessing violence can have a detrimental effect similar to being direct victim of violence. And this report also noted that while there may not always be clear physical signs of exposure to violence, for example, bruises and cuts, children can often suffer from invisible wounds that affect them emotionally or even psychologically. Having said that, children who witness or experience violence, as said in that report, may subsequently suffer symptoms of PTSD, or what we know as post traumatic stress disorder, or depression that can lead to problems in not only their educational attainment but also their psychological development. And perhaps more surprisingly, the National Survey of Children's Exposure to Violence found that more than 6% of the children it surveyed had been exposed to violence within the year preceding the survey, which is pretty interesting. As well as researchers also noted that exposure to violence might have either been direct or indirect. For example, witnessing a violent attack against a family member, it could be against a neighbor or even a close friend, and that the exposure might have occurred in their own homes or in their schools or elsewhere within the communities. So, what is victimology? And what theories of victimization are we going to talk about today? So, if you think about crime, no crime would really be complete without a consideration of the role that victims play in that criminal event. So, victimology, it is a field of study that really developed out of criminology, and it includes more than just theories and extends to all aspects of the scientific study of criminal victimization, including the process of victimization, the criminal, the victim, the justice system, and society. As such, victimologists study particularly vulnerable groups of people and attempt to understand the victimization process. Now, victimologists can be members of various academic or professional organizations. It is actually one of the largest in the World Society of Victimology, and the International Victimology Institute at Tilburg University. This is located in the Netherlands, promotes interdisciplinary research that contributes to a comprehensive, or you should say, evidence based body of knowledge on the status of victims. In Canada, non-profit organizations such as Canadian Resource Centre for Victims of Crime and the Victim Justice Network advocate and provide information about such services, and it also supports victims and the survivors of crimes. Now, moving back to the theories of victimization, while theories of crime causation frequently focuses on the offender, some consideration the role of victim in the setting or the stage leading up to the criminal event should also be noted. As noted in several of the studies that you would come across when you engage with the theories of victimization, Criminal victimization is really a complex process which may involve many parties, and the parties may include the criminal, the victim. You could think about the criminal justice system. It could be the members of the society as well as others. And theories that emphasize the role of the victim in crime causation were some of the earliest contributions to the study of victimology. So let's begin with the term victimogenesis. So, victimogenesis is a term that refers to the origin or cause of victimization, and it can include a cluster of variables that ultimately lead to victimization. So, for example, some individuals can be more at risk of being victimized. They could be older, they could have mobility challenges, or they could even be intoxicated. Others may be at greater risk by not taking appropriate defensive measures, for example, leaving doors unlocked or forgetting to remove the key from a vehicle. People could display wealth, so flashing large amounts of cash or other valuables in a public space, or simply by making other unwise choices, for example, like walking down a dark alley in a high risk neighborhood at 3 a.m. in the morning. So, in any discussion of victimization, however, we must keep this in mind that it is critically important to recognize that while a victim's action may put them in jeopardy, that does not necessarily mean that any subsequent victimization was the victim's own fault. So, if I rephrase that, we should stay away from, let's say, essentially blaming victims for their own victimization, even when their actions are innocent. So, moving on to the next concept, this is closely related to victimogenesis, victim precipitation. So, this is offender victim relationship where the focus of early first generation victimologists who classified victims according to the degree to which they contributed to their own victimization. And these victimologists developed the important notion of victim precipitation and victim proneness. So, this concept of victim precipitation really examines the characteristics of victims, the nature of their surroundings, and the quality of their relationship insofar as they play a role in precipitating victimization. So, victim precipitation really builds on observational or observable correlates of victimization to really explain why some people are more likely to be victimized than others. So, some of the examples that come to mind, so some of the individuals who live in inner city, high crime area, generally speaking, are probably more likely to become crime victims than those who reside in a gated suburban community. Similarly, those who work in certain occupations, for example, late night convenience store clerks, these are people who are probably more likely to become victims of crime than those in certain other occupations, for example, college teachers. So, two types of victim precipitation can be distinguished. One is active and one is passive. Speaking of passive precipitation, it occurs when the victim unknowingly encourages the offender toward criminal action. An active precipitation takes place when the victim literally provokes the victimization. First generation victimologists also developed the term victim proneness to refer to an individual's likelihood of victimization. So, the thrust of the concepts of victim precipitation and victim proneness is not to blame the victim for anything or not to blame the victim for becoming a victim. It is really critical to keep that in mind, but to examine both individual and situational factors that may have contributed to and inhibited the crime. Now, this is especially important in studying patterns of homicide, for example, because quite often a homicide begins as a fight or an argument between people who know one another. The circumstances of the particular encounter determine whether the event will end as some type of assault or as a homicide. So, Marvin Wolfgang, he's a famous pioneer in victim studies, was one of the first researchers to make an effort to assess the extent of victim participation in homicide events. And Wolfgang studied Philadelphia homicides in the late 1940s to early 1950s and concluded that 26% were the result of active victim precipitation. Wolfgang found that causative factors in homicide victimization were a personal relationship between the victim and the victimizer, a disagreement that went out of control, and the consumption of alcohol. Wolfgang found that alcohol played an important role in homicide cases where the victim is a direct positive precipitator of in the crime. He also concluded that the positive and significant association between alcohol and victim precipitated homicides may be explained by the fact that the victim was the first to slap, punch, stab, or in some other manner commit an assault, and that if the victim had not been drinking, they would have been less violent. Other first generation victimologists include Benjamin Mendelssohn and Hans von Hentig. Each developed a typology of victims. So, Mendelssohn, who was a Romanian lawyer, is often referred to as the father of victimology. He's the one who coined the term victimology in the year 1947 and proposed the creation of a Victimological Research Institute, also a journal of victimology, and the establishment of a society for the study of victims. He is best remembered for the creation of a six-part victimology typology based on degree of victim culpability. For the most part, Mendelssohn believed that victims had an unconscious aptitude for victimization. Mendelssohn's six type of victims ranged from the completely innocent victim, completely unconscious person, or let's say an infant, to the imaginary or simulated victim. So individuals who, as a result of psychological disorder, believe that they have been victimized when in fact they have not. And in between were victims with minor guilt, victims as guilty as the offender, and victims with more guilt than the offender. Of his six types, only the completely innocent victim was truly blameless in Mendelssohn's scheme. Hans von Hentig, who wrote in the late 1940s, published an important book, The Criminal and His Victim, in which he created a taxonomy describing how victims might be responsible for the harms that befell them. Von Hentig classified victims into 13 categories depending on psychological, social, and biological factors, which he believed correlated with victimization risk. Von Hentig's typology of victims included categories such as lonesome and heartbroken, depressive, greedy, wanton, and tormentor. The depressive type victim was seen as careless and unsuspecting. The greedy type was easily deceived. The wanton type was needful and therefore vulnerable, while the tormentor type of or frightened victim brought victimization upon themselves. The idea that victims are somehow selected for victimization based on personal traits is still being explored. So in 2013, for example, the results of a study published in the Journal of Interpersonal Violence suggested that individuals who walk in a certain way are at a higher risk of being attacked. So researchers found that an unsteady or slow gait reveals to potential robbers that the victim is slow, unable to escape, and unable to defend themselves, and make an ideal target for interpersonal crime. Moving on to another theory which is the lifestyle exposure theory. So, theories of victimology, which developed in the late 1970s, moved the focus away from the role of victim characteristics as a central cause of victimization and examined the choices that people make that increase their availability to offenders and make them easier targets for crime. So, two major approaches embodying this approach are lifestyle theory and the routine activities approach, which I will just speak about in a bit. So, Michael J. Hindling, Michael R. Gottfredson, and James Garofalo developed the lifestyle exposure theory, also known as lifestyle theory or victimization, in 1978. The theory originally attempted to explain crimes against persons, but it since have been since but it has since been expanded to include property crimes. So lifestyle refers to the style of life or the way a person lives. Lifestyles are composed of repetitive, patterned, regular, and recurrent events that people engage in on a everyday basis. Because lifestyles are associated with exposure to people, places, and times with varying risk of victimization, they determine a person's vulnerability to criminal victimization. So let's simply put certain lifestyles favor victimization because they offer more opportunities for it. Lifestyle theory proposes that demographic variables, including things such as age, gender, race, ethnicity, and socioeconomic status, influence lifestyles and hence determine victimization risk through their effect on lifestyle. Some work, uh, some working in a late night shift in a crime prone area, for example, is likely at a higher risk of victimization than someone who is asleep at home. Similarly, a person who routinely withdraws large sums of cash from the same ATM machine on a regular basis, especially if they frequently visit ATMs in poorly lit areas late at night. These individuals uh, are more likely to be victimized than one who conducts transactions at the teller's window in a bank or who varies their routine. Similarly, drug abusers who sometimes share aspects of their lifestyle with strangers or acquaintances may find themselves the target of robbery or theft, or even end up being arrested as a consequence of the lifestyle choices they have made. Those who participate in a given lifestyle often make rational decisions about specific behaviors, such as in our earlier example of going to a given automated teller machine at a certain time. The same is true of criminal lifestyles. Hence, the meshing of choices made by both victims and criminals contributes significantly to both the frequency and the type of criminal activity observed in society. So, some years later, after the original formulation of lifestyle theory, James Garofalo, one of its founders, observed that victimization is not evenly distributed randomly across space and time. There are high risk locations and high risk time periods. He may have been thinking of special populations, many of whom are heightened or at heightened risk of victimization and for whom such risk is inherent in their status. These include the intellectually challenged, the physically disabled, the elderly, and children. Now, speaking of routine activities theory, the second approach that considers the contributions of individual choices of victimization was proposed by Lawrence Cohen and Marcus Felson in 1979. Writing shortly after the introduction of lifestyle theory, Cohen and Felson noted that routine activities deliver easy crime opportunities to the offender. They stated that the risk of criminal victimization varies dramatically among the circumstances and locations in which people themselves and their property. In other words, the nature or pattern of routine social interaction contributes significantly to both the volume and the type of crime found in society. Cohen and Felton assume that there will always be a substantial number of motivated offenders with the goal of committing crimes against suitable targets in the absence of a capable guardian. So, example, one who effectively discourages crime. So, thinking of an example, a person who routinely walks down a dark alleyway in a high crime area on their way to work for an evening shift at a local pharmacy is far more likely to come into contact with motivated offenders. For example, to be preyed upon by robbers than someone who stays home after dark. Cohen and Felson assume that there will always be a substantial number of motivated offenders, but that suitable targets, either vulnerable people or unattended valuables, and capable guardians, watchful friends, neighbors, the police, or the security personnel, vary with the place and over time. So, social activities engaged in by potential victims who are suitable targets for robbery contribute substantially to criminal opportunities when they are undertaken in the absence of a capable guardian. As when someone wearing valuable jewelry fails to consider the potential threat of being out in public accompanied or unaccompanied by others. So, Izzat Fatah, a Canadian criminologist recognized as one of the leading thinkers in the field of victimology, attempted to integrate the various lifestyle opportunity theories into a comprehensive scheme, and he contended that this scheme comprises 10 components, which he identified as number one, opportunities, which are closely linked to the characteristics of potential targets and to the activities and behavior of these targets. Number two, risk factors, particularly those related to socio-demographic realities such as age, sex, area of residence, and so on. Number three, motivated offenders who do not choose their victims or targets at random but select them according to specific criteria. Number four, exposure of the victim to potential offenders and to high risk situations that increase the risk of criminal victimization. Number five, associations between offenders and victims so that those who are in close personal, professional, or social contact with offenders run a greater risk of being victimized. Number six, dangerous times and dangerous places, which include evenings, weekends, and places of public entertainment. Number seven, dangerous behaviors such as provocation, which increase the risk, especially of violent victimization, and other behaviors such as negligence and carelessness, which enhance chances of property victimization. Number eight, high risk activities, which increase the potential for victimization and can include deviant and illegal activities. Number nine, defensive or avoidance behaviors, which tend to contribute to a reduction in the risk of victimization. Those who take precautions are less likely to be victimized than those who are risk takers. Number 10, structural cultural proneness of people, which means that those who are powerless and culturally stigmatized and marginalized are more likely to be criminally victimized. So, this is interesting to note that the findings of the most recent General Social Survey in Canada indicate that the risk of victimization, and in particular violent victimization, is greatest for a number of groups who are women, those aged between 20 to 24, those involved in binge drinking, those with a mental health related disability, those with a history of homelessness, and those living in a neighborhood with low social cohesion. Moving on to our next theory, which is the deviant places theory. Deviant places theory is spatially oriented. It suggests that victimization occurs most frequently in socially disorganized areas, and that people become victims as a result of their exposure to such areas by living there, transiting through them, or even visiting them. The theory focuses primarily on the geographically determined risk of coming into contact with an offender, irrespective of lifestyle, behavior, or personal characteristics. So, sociologist Rodney Stark proposed deviant places theory in the year 1987 and called it a theory of the ecology of crime. Stark observed that certain locations had high and unchanging victimization rates even after an complete almost turnover of the population, during which previous residents moved away and new ones moved in. He concluded that victimologists needed a kinds of place theory to supplement other theories, which he called kinds of people theories. Stark examined more than a century of ecological research on crime and integrated his findings into a set of propositions. Those propositions focused on neighborhood conditions, and taken together, they form the crux of deviant places theory. Certain neighborhoods, or certain neighborhood conditions, I should say, produce what Stark called stigmatized neighborhoods. So, stigmatized neighborhoods, it is essentially neighborhoods with bad reputations that hold little attraction for those who can afford to live elsewhere. Stigmatized neighborhoods are characterized by crowded homes, transience, dilapidation, and the lack of successful role models. Stark recognized that while stigmatized neighborhoods increase the likelihood of victimization for those living in or visiting them, most neighborhood residents do not become criminal. He also noted that his theory of deviant places depends entirely upon the ecological features which is associated with a given location and not upon racial, ethnic, or other personal characteristics of the people who live there. Now, moving on to our next section, which is the personal impact of victimization and how can the personal impact of victimization really be assessed? So, why don't we examine the personal effects of victimization, looking at things such as psychological, physical, economic, and social impacts of victimization? Now, some of the ideas surrounding the socio-economic impacts. Some authors in the past have identified a number of procedural models that can be applied to a study of victimization process, the experience the victim undergoes during or following victimization. And the victims of crime model developed by Morton Bard and Don Sangre postulated that three stages are involved in any victimization: the stage of impact and disorganization, during and immediately following the criminal event. That was the first one, the stage of impact and disorganization. Number two is the recoil stage, during which the victim formulates psychological defenses and deals with conflicting emotions of guilt, anger, acceptance, and desire for revenge. So the state of recoil is said to last from 3 to 8 months. And the third stage is the reorganizational stage, during which the victim puts their life back together and gets on with daily living in a more or less normal fashion. And some victims do not successfully adapt to the victimization experience, and a maladaptive reorganizational stage may last for many years, really. So, the model developed by Elizabeth Kubler-Ross to describe the stages of grief has some applicability to the victimization process. So, Kubler-Ross described a five-part transitional process of denial, anger, bargaining, depression, and acceptance. So, victims often either deny the likelihood of their own victimization or believe that this can be happening to me. After the victimizing event, many victims feel anger and some express rage toward their victimizers. Bargaining occurs when victims negotiate with themselves as well as with family members, representatives of the criminal justice community, and social service provider over how the victimization experience should be personally interpreted and officially handled. Acceptance occurs when the victim finally acknowledges that victimization has occurred and the victim makes the adjustments necessary to go on with life. Of course, as in the case of other models, the Kubler-Ross models allows for maladjustment in the final phase, as some victims never successfully integrate the victimization experience into their psyches in a way that avoids reduction in the quality of their lives. So, there are countless studies that examined the psychological well being of victims, and they have concluded that criminal victimization can leave psychological scars that last as long as or longer than any physical or financial loss. It can result in anxiety disorders, depression, drug and alcohol abuse, fear, flashbacks, lowered self esteem, sexual dysfunction, thoughts of suicide, suspiciousness, and a feeling of social isolation. It can also result in the development of post traumatic stress disorder or PTSD. It can result in feelings of guilt, with victims of violence experiencing the greatest level of guilt. It can also result in a decreased sense of satisfaction with life and a perception that the world is less caring. So, in a multi year study of crime victims that examined the personal impact of violent crime, results show that 68% of victims of serious violence experience socio-emotional problems as a result of their victimization. Victims of intimate partner violence um, reported significantly greater feelings of distress than victims of stranger violence, and a greater percentage of female than males victims or male victims reported experiencing socio emotional problems regardless of the type of violence or victim offender relationship. And although most of the stress symptoms experienced by victims were found to be emotional, for example, feelings of being worried or anxious, angry, unsafe, violated, vulnerable, distrustful, sad, or depressed, 61% of victims experienced one or more physical symptoms such as trouble sleeping, fatigue, upset stomach, muscle tension, high blood pressure, headaches, problems with eating or drinking for a month or more, and all characteristic of PTSD symptoms. Finally, another study found that a large number of victims of personal crimes reported drinking, smoking, using drugs more often since the offense. And that study found that many victims were critical with themselves for having been victimized, and that many expressed a need to understand why it happened. And a large percentage felt isolated and alone, and even more wanted to inform the offender of how the crime affected them. Finally, quite a few victims reported being afraid of retaliation by the offender. Now, moving on to the section of physical impacts. Now, you see, while some crimes result in the direct physical injury. Others, particularly those that are violent and confrontational, produce other kinds of physical reactions in those who are victimized. So, when talking about physical impacts other than injury may include stimulation of the fight or flight response, which includes increased blood level adrenaline, adrenaline, that is always a tongue twister for me, increased heart rate, hyperventilation, shaking, numbness, crying, dryness of the mouth, loss of bowel control, and a sense that things are occurring in slow motion. So, physical reactions can occur even after the danger has passed and victims have returned to safety. Physical injuries can themselves be minor, so bumps and scratches, or more serious, such as gunshot wounds, broken bones, or even deadly. Severe physical injuries can be life threatening and may result in long term disability or permanent disfigurement. Sometimes physical injuries that result from criminal victimization are not readily apparent, as is often the case in domestic violence situations when bruising and injuries may take time to manifest. Because injuries are not always obvious, law enforcement and other first responders may ask the victims of violent crimes accompany them to the hospital or other medical facility for further examination. The next section is financial impacts. Now, the financial impact of victimization can be measured in terms of immediate loss resulting from the victimization itself and other costs, including medical, repairs to property or possessions, mental health services, increased insurance premiums, and the costs associated with the installation of security systems. So, participation in the justice system can also have substantial personal costs, including transportation, lost wages, childcare, and so on. Likewise, costs associated with relocating a residence in order to move out of a high crime area or away from a home that holds fearful memories can be substantial. Victims may find it difficult to concentrate on work, and their economic productivity may suffer. Finally, funeral and burial expenses have to be borne by the surviving victims of a murdered family member or relative. The financial burdens of victimization may be especially difficult to bear for the economically marginalized, the young, and the disabled. Now we're going to talk about secondary victimization. So, in addition to the literature examining to psychological, physical, and financial realities of criminal victimization, there has been much discussion about secondary victimization, which sometimes blurs the line between victim and offender. So, what secondary victimization refers to is the social injuries that occur not as a direct result of the criminal act, but through the response of social institutions and individuals to the victim. A significant form of secondary victimization happens when the justice system imposes requirements on the victim that are difficult to meet or that interfere with their ability uh, to recover from the initial victimization. So, in some instances, members of the public may be unsympathetic to the victim, communicating messages via social media or in other ways that say they got what they deserved. Likewise, members of the press and media photographers can intrude um, on the victim's privacy and file inaccurate reports of what actually took place. The victim may come to feel frustrated with the justice system and believe that they have been extended fewer considerations than the victimizer, him or herself, or is accorded fewer rights as the criminal justice process wends its way to conclusion. So, cases that are plea bargained are most likely to leave the victim feeling that justice has not been served and that additional victimization has occurred at the hands of the justice system. Finally, the social and financial burdens imposed by justice system participation, for example, attending the trial of one's victimizer, can lead to lost time at work, the inability to fully participate in family life, added childcare fees, Uber and taxi costs, and other kinds of expenses. So, secondary victimization should be distinguished from secondary victims, who are persons not directly affected by a criminal event but who suffer unintended consequences of the victimization of others to whom they are close, like family members, friends, co workers, and even neighbors. In an often cited article, Dean Kilpatrick and Randy Otto contend that promising victims' rights that are not delivered may often involve a certain danger. So, providing rights without remedies would result in the worst of consequences, such as feelings of helplessness, lack of control, and further victimization. Ultimately, with the victim's best interests in mind, it is better to confer no rights than rights without remedies. Now, moving on to the section on victim rights and describing the emergence and the development of victim rights and how we identify the ways in which such rights can be recognized. Now, it's fueled largely by the expansion of theoretical study within the field of criminology of the victim as a participant in the criminal event, a focus on the victim's role in the formal criminal justice process took hold in Canada in the late 1980s and early 1990s. The emergence of victims advocacy and support organizations served to further highlight the need to critically examine the role and rights of victims within the criminal justice system. So, what is the history of the victim? Um, if we look into how they were treated and the procedures in place. So, in early times, victims took the law into their own hands. If they were able to apprehend their victimizers, they enacted their own form of revenge and imposed some form of personal retaliation. One of the earliest known legal codes, the Code of Hammurabi, circa 1750 BCE, required that many offenders make restitution. So, if the offender could not be found, the victim's family was duty bound to care for the needs of the victim. And eventually, crimes came to be understood as offenses against society, and the victim was forgotten. By the late Middle Ages, the concept of king's peace had emerged, wherein all offenses were seen as violations of imperial law. The notion of private injury became one of public wrong, and the law of wrongdoing became the law of crime. It became the duty of local governments to apprehend, try, and punish offenders, effectively removing the victim from any direct involvement in judicial decision making. So, society's moral responsibility towards making victims whole again was forgotten, and victims, as a class, were moved to the periphery of the justice process. And justice for the victim was forgotten, translated instead into the notion of justice for the state. So, by the 14th century, the victim was no longer the focus of the criminal process, and the notion of an active role of the victim did not re emerge until the 19th century. It wasn't until the 20th century, however, that a renewed interest in the plight of victims led to a resurgence of positive sentiments around the world and discussion of the role of the victim in the formal criminal justice process ensued, with supporters and detractors of the victim's right to participate in the process lining up on opposite sides of the argument. And much of the current academic debate continues to center on the discussion on whether or not increased protection for victims can be achieved only at the expense of the rights of the accused. So, for example, some victims' rights advocates recommend that victims be allowed to express an opinion or recommendation as to a convicted offender's sentence at the sentencing portion of the formal court process. Those who caution against the increased participation of victims in the court process argue that this will only serve to whittle away at the accused's right to due process and turn the sentencing into an opportunity for victims to seek revenge. With the emerging discipline of victimology, academic discussion focused on the development of a pedagogical basis for the growing victims' rights movement. So, this discussion centered largely on the two models of criminal justice put forth by Herbert Packer in 1968 in the limits of the criminal sanction. Uh, Packer represented the crime control model and the due process model. The former model describes an assembly line approach to justice, focusing on the efficient repression of crime and the safety of the community. The latter model discusses an approach to criminal justice that emphasizes civil liberties and the importance of the verdict rather than the efficiency of the process. In the late 1990s, Kent Roach, the Dean of Law at the University of Saskatchewan, proposed a third model as a theoretical base for victim rights, referring to it as the victims' rights model and calling for more laws and prosecutions, a greater role for the victim in the trial, and more services and support for victims. So Roach developed his model by distinguishing between what he identified as the punitive victims' rights model and the non-punitive victims' rights model. He described the punitive approach as one resembling the crime control model because it focuses on the enactment of criminal law, prosecution, and punishment as ways to control crime. His non-punitive model of victims' rights, on the other hand, looked away from the reliance on criminal sanction and punishment and toward the prevention of crime and restorative justice. Roach went on to advocate that the non-punitive approach would seek to shift the focus of importance away from traditional crime control strategies and agents, such as the police, prosecutors, defense lawyers, and judges, and toward the victim, the offender, families, and supporters. And victims, in turn, would play the most significant role in determining how the offender should be dealt with. Now let's talk about the victims' rights legislation. So, against this backdrop of increasing recognition for victims, a number of laws have been developed, the earliest of which were focused on providing compensation primarily to victims of violent crimes. The first modern victim compensation statute was developed by New Zealand in 1963. This act was known as the Criminal Injuries Compensation Act, and it provided an avenue for claims to be filed by victims of certain specific violent crimes. 1 year later, partially in response to a movement led by the social reformer Margaret Fry, Great Britain established a similar law. In 1965, California passed the first piece of US legislation intended to assist victims of crime, and today all 50 states have passed similar legislation. The first Canadian criminal injuries compensation plan was created in Saskatchewan in 1967, and by 1988, a compensation program was available in every province and territory, providing financial compensation for injuries or death resulting from a crime of violence committed by another person. Now, international attention to the issue saw that the first international symposium on victimology held in Israel in 1973, and at the 1979 Federal Provincial Conference of Ministers responsible for criminal justice, the issue of victims' rights was raised by provincial ministers and subsequently formally brought to the attention of the federal government. A loose coalition of Canadian feminist organizations, Canadian victim assistance programs, and the strengthening US victims' rights movement came together to move the issue to the forefront. In about 1983, a federal provincial task force on justice for the victims of crime made 79 recommendations addressing the needs of victims and the requirements for effective victim services, many of which are in place today. And among these are provisions for improvements in emotional and practical assistance for victims, as well as provisions within the Criminal Code of Canada that ensures criminal injuries compensation, the increased use of restitution, and the introduction of the idea of a victim impact statement in the pre sentence report. Now, in the mid 1980s, a number of nations had signed on to the 1985 United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuses of Power, which is essentially a declaration of general principles. In adopting the declaration, the General Assembly of the UN stated that it was cognizant that millions of people throughout the world suffer harm as a result of crime and abuse of power, and that the rights of these victims have not been adequately recognized. And that despite the lack of concrete details regarding implementation of these rights for victims, the document really served as a catalyst for similar documents around the world, not the least of which was the Canadian Statement of Basic Principles for Justice for Victims of Crime, endorsed by the provincial and territorial ministers of justice in 1988, and it was amended in 2003. These 10 principles served to guide the development of policy and legislation for the victims of crime at both the federal and provincial levels, and it included language around the requirement for privacy, safety and security, and access to information about their cases within the criminal justice system and about victim services. A 1998 report from the House of Commons Standing Committee on Justice and Human Rights, titled Victim Rights, A Voice, Not a Veto, made a number of recommendations regarding further amendments to the Criminal Code to strengthen the voice of victims of crime. Most provinces and territories in Canada have enacted legislation to promote and protect the interests of victims. Almost all the provincial governments have also enacted legislation to recognize the rights of victims. In 1986, Manitoba was the first province to incorporate principles from the UN Declaration into its own law. And many of these provincial bills emphasize the notion of empowerment for the victim, as well as provide rights of participation and um, notification. Ontario's legislation, known as an Act Respecting Victims of Crime, Victims' Bill of Rights, is emblematic of the rights enshrined in most provincial and territorial legislation. In 2005, a national office for victim was established under the auspices of Public Safety Canada, and as a central resource under federal responsibility, the office provides general information for victims and the public and makes referrals on behalf of victims to Correctional Service Canada and the National Parole Board when required. 2 years later, the independent office of the Federal Ombudsman for Victims of Crime was created. By facilitating access of victims to existing programs, addressing complaints of victims about legislative compliance, enhancing awareness of criminal justice personnel and policymakers about the needs of victims, and identifying trends that may adversely affect victims. The Office of the Ombudsman acts as a watchdog to ensure that the federal government somewhat meets its responsibilities to victims of crime. The Policy Center for Victim Issues within the Department of Justice engages in legislative reform, consultation, policy development, research, and project funding. The Federal Victims Strategy was created in 2011 within the Department of Justice and was designed to bring together federal efforts to give victims of crime a more effective voice in the criminal justice system. Working with other federal institutions as well as victims, victim advocates, and provincial and territorial governments, the Department of Justice develops policy and criminal law and explores best practices to address victims' needs. Within the Federal Victims Strategy, the Victims Fund provides financial resources to provinces, territories, and non governmental organizations whose activities and operations support the victim strategy. On July 23, 2015, or the year 2015, Bill C-32, the Victim Bill of Rights Act, came into force, and this legislation created the Canadian Victims Bill of Rights to provide clear statutory rights at the federal level for victims of crime for the first time in Canada's history. The Canadian Victims Bill of Rights establishes statutory rights to information, to protection, participation, and to seek restitution, and it ensures that a complaint process is in place for breaches of these rights by a federal department or agency. The quasi-constitutional status of the Bill of Rights affords a number of remedies for victims who believe their rights have been violated, and time will tell how and if these rights are ensured both at the federal and provincial levels of the governments. Now, looking into an overview of the Canadian Victims Bill of Rights, so what the Canadian Victims Bills of Rights enshrines, it enshrines the following rights for victims. So, one of them being general information. So, with general information, every victim has a right on request to information about the criminal justice system and the role of victims in it. Also, the services and programs available to them as a victim, including restorative justice programs, and their right to file a complaint for an infringement or denial of any of their rights under this Act. Secondly, it shares investigation and proceedings. So every victim has the right on request to information about the status and outcome of the investigation into the offense and the location of proceedings in relation to the offense when they will take place and their progress and outcome. They also have information about offender or accused. So every victim has a right on request to gain information about reviews under the Corrections and Conditional Release Act relating to the offender's conditional release and the timing and conditions of that release, and hearings held for the purpose of making dispositions as defined in subsection 672.1.1 of the Criminal Code in relation to the accused, if the accused is found not criminally responsible on account of mental disorder or unfit to stand trial, and the dispositions made at those hearings, as well as protection security. So every victim has the right to have this security considered by the appropriate authorities in the criminal justice system. Few other points. So protection from intimidation and retaliation. So every victim has the right to have reasonable and necessary measures taken by the appropriate authorities in the criminal justice system to protect the victim from intimidation and retaliation. Privacy. So every victim has the right to have their privacy considered by the appropriate authorities in the criminal justice system. Identity protection. Every victim has the right to request that their identity be protected if they are a complainant to the offense or a witness in proceedings relating to the offense. Testimonial aids. Every victim has the right to request testimonial aids when appearing as a witness in proceedings relating to the offense. Participation views to be considered. So every victim has the right to convey their views about decisions to be made by appropriate authorities in the criminal justice system that affect the victim's rights under this act, and to have those views considered. Victim impact statement. So every victim has the right to present a victim impact statement to the appropriate authorities in the criminal justice system and to have it considered. Restitution order. Every victim has a right to have the court consider making a restitution order against the offender. Enforcement. Every victim in whose favor a restitution order is made has the right, if they're not paid, to have the order entered as a civil court judgment that is enforceable against the offender. Remedies. Under the Canadian Victims' Bill of Rights, when a victim believes that their rights have been breached, the victim first files a complaint with the appropriate federal department or agency. The legislation includes a requirement for all federal departments and agencies that have responsibilities under the Canadian Victims' Bill of Rights to have internal complaint mechanisms, such as a mechanism that is accessible to victims to review complaints, make recommendations, to correct any infringement, and notify victims about the results of the review. Also, complaints regarding provincial or territorial agency, including police, prosecutors, and victim services, will be addressed in accordance with the applicable provincial or territorial legislation. Now, speaking of victim services, looking at some of the services available to victims of crime and in what ways are they provided. So, in addition to the development of and the changes to legislation, as we covered quite intensely, the creation of national and provincial government advocacy of offices, the movement to recognize the needs and rights of victims, has led to the development of a variety of services and programs across the country. According to the most recent formal victim services review, of the 760 victim services identified across the country, the majority addresses issues of protection, support in crisis situations, information about the criminal justice system, and assistance with participation in the criminal justice system, and have provided about 460,000 primary and secondary victims, the majority of whom were female. The Victim Services Directory, maintained by the Policy Center of Victim Issues, provides an index of 816 victims by the province, types of victimization, and types of service. And most of these services were not available as recently as even 30 years ago. And speaking of a few, so there are police-based services. Over a quarter of all victim services are police-based, usually located in police departments. These types of programs are designed to help victims as soon as possible after their contact with the police and criminal justice system begins. These types of services typically include death notification, information about the investigation, assistance with various applications for compensation, and referrals. In order to provide this support to victims, many police services across Canada now have in-house victim service units, usually staffed by civilians, volunteers. These services are available 24 hours a day for immediate victim support. For example, in the case of a fatal car accident, responding police officers can call upon their department's victim services unit to provide crisis intervention at the scene of the accident. Such services not only allow police officers to resume their duties, but also ensure that the victim is supported by a trained professional. Many victim services units also volunteers who represent various cultural, ethnic, and linguistic groups to help the specific needs of victims. Some provinces have also established and funded independent crisis intervention services that provide victim support through referrals from police. In Ontario, for example, the Victim Crisis Assistance Ontario (VCAO) is found in numerous centers across the province. A full time coordinator and a group of trained volunteers who are available as support to police at the scene of a crime. Staff most VCAO programs available 24 hours a day and 7 days a week. VCAO personnel help victims cope with the impact of the crime of tragic circumstance. This may mean helping an elderly woman clean up after her home has been burglarized or burglarized. I apologize. Another tongue twister. Or spending time with survivors of a fatal um, car accident, and follow up is often provided in the form of referrals for ongoing counseling if required. The second one is court based services. So, most court based victims programs are located within the courthouses and work closely with the Crown's office. Most assist those victims whose cases have resulted in prosecution. They emphasize court preparation and are designed to assist the victim through the trial process. One of such program is the Victim Witness Assistance Program located throughout Ontario. It provides services such as notification of court dates and adjournments, guided tours through the courtroom, explanations of court proceedings, and emotional support throughout the trial, especially on the days of victims' testimony. Many provinces also have specialized court based support programs for child victims and witnesses. The recognition of the victim's involvement and the need for support throughout the court process has resulted in a number of provisions outlined in the Criminal Code of Canada with special attention to victims of violence. For example, Section 722 allows victims to record a personal statement describing the emotional suffering, trauma, and financial hardship experienced as a result of their victimization, also known as victim impact statements. These accounts are introduced into court after conviction and prior to sentencing. They are most common in cases of interpersonal victimization, and judges are expected to consider these statements in arriving at an appropriate sanction for the offender. The extent to which victim impact statements affect a judge's sentencing determination is debatable, and most victims do not submit one. But proponents of victim impact statements contend that they allow victims to have their say and feel involved in the criminal justice process, providing for many uh, cathartic emotional outlet. Victims may present their statements in writing, orally, or by pre recorded video. Survivors of homicide victims can also present an impact statement when an offender who is sentenced to life implies to reduce the length of time until parole, as provided in Section 745 of the Criminal Code. A number of other criminal code provisions are aimed at reducing the secondary victimization often experienced by people who appear as witnesses at trials. In order to protect the identity of victims, a trial judge may override the fundamental principle of justice that trials be public and issue an order to exclude all or any members of public from the courtroom for all or part of the proceedings. So, Section 486, subsection 1 are rarely done. This action is meant to allow for the proper administration of justice by allowing a victim or witness to testify free from stress or fear. These public exclusion orders are most often used in cases involving child witnesses, something to keep in mind. Additionally, Section 486, subsection 3 states that judges can order the identity of the complainant or of a witness, and any information that could disclose the identity of the complainant or of a witness shall not be published in any document or broadcast in any way. These publication bans can be imposed in specific types of cases only, such as those involving sexual assault, incest, extortion, or sexual offense involving children. Contravention of a publication ban is a summary conviction offense. Subsections 276.2 and 276.3 restrict the publication of proceedings to determine the admissibility of evidence regarding a sexual assault complaint's sexual history. So, other provisions intended to facilitate the participation of witnesses include subsection 486 1.2, which permits a support person to be present in court with a witness and under the age of 14 in sexual offense proceedings, and subsection 486 2.1, which permits a sexual offense complainant who is under the age of 18 to provide their testimony from behind a screen or by closed circuit television. This provision has recently been expanded to include victims and witnesses in prosecution, and I apologize. This provision has actually been expanded to include victims and witnesses in prostitution and assault cases. Subsection 715.1 permits as evidence a videotaped version of a witness's testimony in proceedings relating to sexual offenses where the victim or witness was under the age of 18 at the time of the offense. Moving on to the next section, victims and corrections. So, victim involvement with the criminal justice system often continues after the offender is convicted and sentenced. So, the Federal Corrections and Conditional Release Act, CCRA, for example, outlines the role of the victim in the parole process. In addition to those victims' rights, as we spoke about a few minutes ago, the victim and or any other interested party may attend a parole hearing provided a written request has been made in advance of the hearing, and victims must travel to the location of the hearing and absorb any associated costs. Written transcripts of the hearing are made available upon request to those victims who cannot attend a hearing. In addition, some provinces have adopted legislation and procedures really allowing the victim to remain informed of changes in the status of incarcerated offenders. Amendments made to the CCRA in 2007 ensure that victims can receive advance notice and reasons for offender transfers to minimum security facilities or temporary absences from institutions, as well as information about offender program participation and any convictions for any serious disciplinary offenses. The Canadian Victims' Bill of Rights introduced a formalized victims' complaint process for victims who believe their rights have not been respected in the parole process. In BC, the Victim Safety Unit of the Ministry of Justice operates an automated victim notification system, so victims can register to be notified of changes in the custody status of an offender. The notification system provides victims with a personal identification number to assess such information about their cases. There are also system-based services, and this approach to the provision of assistance to victims allows victims or assistance to victims emphasizes a system-based approach instead of one that police are or is court-based. It allows victims to receive all their services from one location and assists victims throughout their contact with the criminal justice system. This may include, but obviously is not limited to, providing information, support, and referrals, short-term counseling, court preparation, and accompaniment, victim impact statement preparation, and liaising with police, courts, crowns, and corrections. And most of these services and supports to victims have been enshrined as rights of victims in the Canadian Victims' Bill of Rights. The right to information about investigations, proceedings on the accused, the right to protection of identity and privacy, and the right to participation in the criminal justice process are all good examples. Now, moving on to victim restitution and compensation. So, just kind of describing the concepts of victim restitution and compensation and how these processes work in Canada. So, much of the philosophical basis of today's victims movement can be found in restorative justice model. Um, Restorative justice has both a community safety dimension and an offender accountability focus. So, the community safety dimension recognizes that the justice system has a responsibility to protect the public from crime and the offender. It also recognizes that the community can participate in ensuring its own safety. The accountability element defines criminal conduct in terms of obligations incurred by the offender, both to the victim and to the community. And restorative justice also has what some describe as a competency developed element, which holds the offenders who enter the justice system should leave it more capable of participating successfully in a wider society than when they entered. An important aspect of restorative justice is victim restitution. So, sentencing options to seek to restore the victim frequently focus on restitution payments that offenders are ordered to make, either to the victim or to a general fund, which may then reimburse victims for damages and or losses. And restitution encompasses the notion that criminal offenders should shoulder at least a portion of the financial obligations required to make the victim whole again, and places responsibility for the process back upon the offender who caused the loss of the wholeness initially. And restitution has many advocates who claim that it benefits society by leading to an increased sense of social and individual responsibility on part of the convicted offender. At one time in Canada, the responsibility for requesting restitution lay with the victim. Many who were not aware of this option failed to petition the court, and restitution was not ordered. Currently, a judge can unilaterally order restitution or do so at the request of the Crown. It can be so ordered as a standalone sentence or as part of another, such as a probation order or a conditional sentence. These types of sentences help ensure the beneficiaries of the restitution order receive payment. Failure to pay in either instance can lead to a breach of the sentence and incarceration. Beneficiaries can also use civil courts to enforce a restitution order. Subsection 738.1 of the Criminal Code of Canada extends the use of restitution to criminal cases involving criminal injury and allows a judge to impose a sentence of restitution to cover expenses to the victim relating to things such as loss of income or support, costly dental work, or physiotherapy expenses. In addition to the case of an offense causing bodily harm to the offender's spouse or child, in instances of family violence, the subsection allows restitution to be ordered for readily ascertainable expenses incurred by the victim as a result of moving out of the offender's household for temporary housing, childcare, food, and transportation. Until 2018, Section 737 of the Criminal Code of Canada required a victim surcharge to be automatically imposed in addition to any other sanction handed down to an offender convicted of an offense in the Criminal Code or the Controlled Drugs and Substances Act. So in 2018, the Supreme Court of Canada upheld an Ontario court ruling and declared the surcharge as unconstitutional on the grounds that a mandatory victim surcharge fine does not allow sentencing judges the discretion to consider mitigating factors and can thereby constitute cruel and unusual punishment. In 2019, an omnibus bill, uh, the an act to amend the criminal code, the Youth Criminal Justice Act, and other acts reenacted the Section 737, requiring a surcharge to be imposed for every offense in which an offender is sentenced. And amounts for the surcharge, as stipulated in the criminal code, are 30% of any fine imposed on the offender, and if no fine is imposed, $100 in the case of summary conviction offense, and 200 for an offense punishable by indictment. The revenue raised remains in the province or territory where it is imposed. However, greater judicial discretion to depart from imposing the surcharge is now granted if the court deems that its imposition would cause undue hardship to the offender. According to the British Columbia Civil Liberties Association, forcing offenders to pay the surcharge even when they had no ability to pay meant that many people were going to jail simply because they were poor. Victims' rights groups raise concerns that services for victims will suffer from reduced funding through the surcharge. According to Heidi Illingworth, federal ombudsman uh, for victim for victims of crimes, the judges need to have some discretion, but it really um, it's critical that victim services get funded properly and not just after thought funding. So we have groups and communities who don't have enough, which is the reality. So the evaluation of victims recognition began with the creation of victim compensation programs across the country. By 1988, every province offered a compensation program for victims of crime. Every provincial compensation program is unique, but all includes time limits on the filing of an application and set maximum awards amounts per applicant, varying from $5,000 to over $100,000, and some include secondary victims. In the case of Nova Scotia, maximum awards included $2,000 for counseling for victimization or individuals victimized, and $4,000 for counseling for immediate families of homicide victims. In addition, most plans allow those injured while preventing a crime to qualify for compensation. In all plans, payments for lost wages, medical expenses, and prescription drugs are commonly made. Some provincial plans compensate victims for general damages, including pain and suffering caused by the offense. Victims who are responsible in some significant way for their own victimization may receive a lower reward or be disqualified completely. Other factors taken into consideration include proper knowledge of the offender's criminalistic tendencies, intoxication, and provocation of the offender, and these factors may result in no reward or a reduced one. And although many tout the benefits of victim compensation programs, some studies of the effectiveness of government sponsored compensation programs have found the most crime victims are reluctant to seek compensation, and that those who do are generally from households from higher incomes or with higher incomes. Frustrations with delays, poor information about the programs, and unmet expectations regarding assistance with psychological and support needs as well as financial needs were also cited as limitations. A report by the Ombudsman of Ontario titled "Adding Insult to Injury" strongly criticized the province's Criminal Injuries Compensation Board, calling it a colossal failure that needlessly re-victimizes people. In his report, the ombudsman claimed that the board has become mired in bureaucratic red tape that serves only to delay or deny compensation to victims. He also detailed the cases of several victims, including one who was forced to choose between buying food and burying his murdered daughter, and another who had his claim returned because he had failed to dot an I on his form. In 2019, the Ontario Criminal Injuries Compensation Board was overhauled and no longer provides compensation awards but rather supports access to specific services for victims such as short term counseling, home safety equipment, and temporary accommodation. New timelines for application require a victim to report the crime to police and apply to the newly named Victim Quick Response Program within 45 days of the crime. And victims' rights advocates say that the new approach does not recognize the way trauma develops for victims of crime and warn that time cuts off and the focus on temporary assistance will shortchange many victims. Now, having said all of that, what are the future directions in victimology? Initiatives taken by the federal and provincial governments in Canada in recent years have done much to emphasize and highlight the rights and role of victims within our criminal justice system. the passage of the Canadian Victim Bill of Rights has done much to emphasize and highlight the rights and role of victims within our criminal justice system, and changes have occurred. Recently, amendments to the National Defence Act extended the statutory rights of victims enshrined in the Canadian Victims Bill of Rights into the Canadian military justice system, and thereby afforded the military personnel who allege sexual and physical misconduct. Additionally, federally run services for victims of crime have developed their own complaint mechanisms for victims and have streamlined their processes across departments. There have been more technological developments to help survivors participate in parole hearings, especially significant given the realities of the situation such as COVID-19 pandemic. However, despite progress such as this, there is still concern that the needs of victims are not being fully met. Challenges with implementation of the Victims' Bill of Rights continue to be highlighted. One often cited concern, for example, is the balance between general privacy rights and the right to information by the victim upon request. So, victims' advocates claim this places an unfair onus on survivors to request information they may not know exists or be in a frame of mind to request. For example, victims of a federally sentenced offender can register to receive information about the offender in custody, about any releases, or to participate in parole hearings. The National Office for Victims, which administers the program, believes that it is primary I apologize. It is a privacy violation to contact victims to inform them about the program, so they are forced to rely on general public outreach campaigns who notify Canadians about the program. In a letter to the Minister of Public Safety and Emergency Preparedness, Heidi Illingworth, federal ombudsman for the victims of crime, reiterated that victims' rights to information, participation, and protection in the criminal justice system still needs strengthening. Her recommendations include equitable treatment of federal victims across provinces, an automatic registration process to proactively inform victims about their rights, ongoing information about cases in simple language, and the adoption of standardized procedures for interacting with victims. An internal Justice Department report from 2014 says that Canadians have little confidence in the courts and the prison system. The report uses data from many years of opinion polls and research, some of it unpublished, to emphasize that while public confidence in the police remains high, Canadians believe the courts are slow, sentences are lenient, and offenders are not rehabilitated through the correctional system. In addition, some of the research indicates that the public believes that victims are often ignored in the criminal justice proceedings. A 2020 public opinion poll conducted by the Angus Reid Institute reports that this lack of confidence continues. It cites that Canadians have an overall lack of confidence in their federal and local police services as well as the provincial court system. 15% of Canadians reported being victim of a crime that involved the police in the previous 2 years. Some claim that the victims movement has been adopted by governments to boost ratings and opinion polls and justify a platform of increased penalties for offenders as the primary way of recognizing rights. Ezrat Fatah asserted crime victims are not the first group whose cause is exploited by unpopular governments seeking a higher rating in public opinion polls, but opportunistic politicians seeking electoral votes or by incompetent public officials trying to detract attention from their failure to control crime and reduce its incidence. Others, such as Kent Roach, believe that there needs to be a fundamental structural change away from an adversarial approach to our criminal justice system and outward a restorative, victim-centered approach before victims' rights can be truly respected. So until that time, any recognition of victims' rights and roles in the criminal process cannot be considered as anything more than window dressing, and the modern crime victim can be seen only as a participant who is all dressed up with nowhere to go. Arvin Waller, a leading Canadian academic, advocate in the field of victimology, and president of the International Organization of Victims Assistance, suggested that much of what is needed to support victims of crime has already been agreed upon through the international recognition of the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, adopted by the General Assembly of the United Nations in 1985. While stated that there is much rhetoric on doing justice and support for victims, indeed, there are often laws and patchwork of services to be implemented uh, as for those laws, but much needs to be done to make support services universal, to get restitution paid, and to provide equitable compensation. To struggle to recognize crime victims' needs and rights continues, while the movements such as hashtag MeToo help to keep the realities of victims in the forefront. There is still much work to ensure that victims are formally included in the criminal justice process, and governments at all levels have formally acknowledged this. In addition to resources for the development and provision of services for victims, attention is also being paid to research the realities and the needs of crime victims. A grant from the Social Sciences and Humanities Research Council (SSHRC), which is a federal research funding agency, has supported a multi-year study by Benjamin Rubach of Algonquin College in Ottawa, looking at resilience and survivors of violent crime. In a yet to be published paper, the study examines ways in which violence affects health and the ways in which victims change following an experience of violence and subsequent interaction with police and the justice system. Additional funding will allow Roebuck to review best practices and systematic barriers across different victim service sectors, as well as develop tools to foster vicarious resilience for service providers. Just to summarize what we spoke about today, so victimology, it is a subfield of criminology which extends to all aspects of the scientific study of criminal victimization, including the process of victimization, the criminal, the victim, the justice system, and the society. While early theories of victimology tended to blame the victim for their own victimization, more recent victimological approaches examine lifestyles, routine activities, and features of deviant places as factors that contribute to criminal victimization. What we also learned is the victimization experience significantly impacts victims of crime. Victims are impacted along personal, physical, financial, and social dimensions, and we examined each of them. The Code of Hammurabi required that many offenders make restitution. By the late Middle Ages, the concept of king's peace had emerged, wherein all offenses were seen as violations of imperial law, and the situation remained largely unchanged until the 20th century. So, a focus on the role of the victim in the formal justice, criminal justice process took hold in Canada in late 1980s and early 1990s, and it really evolved into an expanded emphasis on the rights of victims. Provincial and federal governments in Canada have enacted legislation to recognize and support victims' rights, services, and programs. We spoke about the Canadian Victims Bill of Rights being a federal legislation establishing statutory rights to information, protection, and participation, and to seek restitution for victims of crime. We also just spoke about the current services for victims of crime, how they are made available in conjunction with the police, the Crown, the courts, and correctional services across the country. We spoke a bit about restorative justice, which is a concept that underlines much of today's victims' movements, emphasizes both offender accountability and victim reparation. Restitution, which is typically conceived of as payments by the offender to the victim, is intended to make the offender whole again, and restitution works through court imposed fines and garnishments. A judge can unilaterally order restitution or do so at the request of the Crown. Restitution can also be ordered as a standalone sentence or as part of another, such as a probation order or a conditional sentence. Compensation or payments to victims generally made by a government agency are provided as compensation for lost wages. It could be medical expenses and pain and suffering. And every province offers a compensation program for victims of crime. Questions continue to be asked about the needs of the victims and the impact of the criminal justice system process on the well-being of victims and the role of the victim in the justice process, and whether our current criminal justice structure ensures the true participation of victims.